Good morning. My name is Dick Gleason, and I'm here with a friend, Amy Kullar, who is an expert at elder law. And today she's going to talk to us about some of the legalese and the paperwork that kind of supports that legalese that need to be dealt with as we approach the time for us to, when our body is going to let go, and we need to have our estate put in play. So what I would ask Amy, if she could give us an outline of what documents, let's talk about the documents, the more simpler part, that people need to have in hand when a relative, for example, who's aging.
Well, thank you, Dick. Thank you for that. It's my pleasure to be here today. As Dick said, I'm an expert in elder law. I practice mainly in estate planning and elder law and Medicaid planning, and that entails all of these things. Number one, when people are aging and when you're becoming retired, it's really important to think about how you're going to manage your assets and your health care if you ever get to the point where you need assistance with that or you're unable to do so. So the two most important documents for my clients are always, number one, a durable power of attorney, which is a document whereby you would appoint an agent, as someone you trust very much, to manage your finances on your behalf, and also any real estate you have, they can manage your finances and real estate on your behalf under this document. For elders, it is very important that when you're getting this power of attorney, that you get something that's called an instant power of attorney, meaning it goes into effect as soon as it's signed, so that you know that no matter what happens in the future, medical-wise or with your family or finances, that you have protection in place for you. And under Massachusetts law, the powers of attorney are super important because it's one of those documents while we're alive that would prevent government involvement in our lives. And what I mean by that is that the statute that governs powers of attorneys in Massachusetts says that it's a rebuttable presumption, meaning the person you're naming in that document is the person who would be in charge of you if there was ever a court action to assess whether or not you need assistance legally with your finances or real estate. So a power of attorney is so important. For most people, if you're in a long-term marriage and you and your spouse are cognitively on the same level, most people name their spouses. You can also name siblings, you can name children, you can name any other relative or friend that you trust implicitly. So it's a super important document. And then in tandem with that, the other living document that is very important is the healthcare proxy. So in Massachusetts, you can easily get a healthcare proxy document. You don't need a lawyer for this. You can go to your physician and ask them for a healthcare proxy. And you will appoint someone, again, it's usually a spouse for most people if you're married, or children, to be the person who would make your medical decisions for you if a doctor ever certifies that you are no longer able to make those medical decisions. So those are super important documents to have. The healthcare proxy is something that everyone should have in place, because if you do have a medical emergency or you become incapacitated and you don't have a healthcare proxy, most likely not even your spouse is going to be allowed to make decisions for you without a court order. So again, those are very expensive, and we want to minimize trauma that's already existing in your family circle because you're incapacitated and now your poor family has to go to court. So we always want to avoid court involvement in our lives. And the power of attorney and the healthcare proxy are the two most important documents to help any elder maintain their autonomy for as long as they can.
Massachusetts, I don't know if it's called or forbids, but you can't do a living will and have it have a legal ramification in this state, correct?
That's true. So a lot of people know the living will document as maybe the 5 wishes that is often handed out in places like a council on aging or hospice. And 5 wishes are great for organizing your thoughts about how you'd want to be treated in an end-of-life situation, but you are correct. The living will or the 5 wishes is not legally binding against a physician who's ultimately working with your healthcare agent to make decisions. the healthcare agent has to be familiar with your living will or your 5 wishes so that they can make the decisions that you would have made.
Which complicates the healthcare proxy in a way, doesn't it?
It can complicate it. Any individual that you're choosing to be your healthcare agent, you do have to have a conversation with them about, very specifically, about how you want to be treated in an incapacity situation or in an end-of-life situation so that your wishes are followed. So the person that you're naming as a healthcare agent should also have a copy of your living will document. But as living wills, since they're not legally binding against physicians, they need to be, your agent needs to be very informed with what your wishes are.
So it doesn't mean that a living will can't be created. It simply means if you go into court, that's not evidence that...
It's evidence. So what I like to say a living will is for is, especially if maybe you don't have a spouse with us any longer or you don't have a spouse at all, then if you're naming children and you have more than one as your healthcare agents, I always insist that my clients sign living wills so that there's no question that this is the wish of the parent, and we can't have the other kids turn around and say to the healthcare agent, "You killed mom," because those. The whole purpose of elder law for me in my practice is to not create bad feelings among the family members, because generally, if you're meeting with an elder lawyer and it's an emergency or a crisis situation, it's not your best day. So we really want to have clear instructions to our family members, so that's one less thing they have to worry about.
Well, and I'm not doing a commercial for you, but I think that, but it was, what was nice is that you did my mother's power of attorney, you did her, the proxy, the healthcare proxy, and then you also did her will.
Yes.
And they served multi-functions. So for example, I have a disabled brother.
Absolutely.
Who you were kind enough to put together a trust, but it was within my mother's trust. So
yeah, every estate plan that I make is absolutely 100% tailored to every person, and unique situations do arise. A lot of my clients have adult disabled children, and they are fine probably while they're living with you throughout their life and taken care of and loved and supported. But what happens when our elderly parent passes away? That's a scary thing for a lot of families to contemplate. So absolutely any adult disabled child can be a beneficiary of an estate through supplemental needs planning. And it can be a simple trust within a trust, like your mother had a big family trust that she had, and your brother's share would have been supplementally needs protected. But you can also do a standalone trust for our adult disabled children so that they will have their own governing document for how their finances are going to be used.
But they can't control it, though.
They can never be the trustee, and the specific federal law that allows these kinds of trusts says that the funds within the trust can only be used to supplement, but never supplant any programs that, any public programs that the beneficiary is otherwise entitled to. So. A lot of the times what we'll see is that maybe my elderly or someone elderly passed away and had an adult disabled child and did no planning, and I'm meeting with the other family members to try to sort out what we can do to help this person. But what typically will happen is if they're an individual beneficiary of their parents' estate, is in that first year it's pretty rough because they can lose a lot of their benefits that they've been relying on for their entire lives.
Well, and from my view, it was a difficult thing because I was the trustee of my mother's estate, but I had to be very, very careful to make sure that everybody was getting an equal split of that estate.
Oh yeah, and it's so important to make sure that you do your fiduciary duty. So when you serve as a trustee, you're the person who's legally responsible for the assets within the trust. And you have a fiduciary obligation to the beneficiaries to make sure that you manage those assets correctly and that you distribute them according to the wish of the person who created the trust. So it is a huge job.
The hardest part of doing that job, though, is you say, well, wait a minute, now I've got this money in the bank in a trust, and he doesn't want anything.
Oh,
he doesn't need anything, and I can't convince him that we should go buy some new clothes for you, or we should do this, or we should do
it's
that.
hard. I mean, your brother is in a unique position where he's very well supported, but not so many disabled adults are as fortunate.
Right.
So I'm so glad that he's in that position to be cared for, but it's not too late for anyone to do this for their own adult disabled child. if they're still with us.
Well, and I think one of the things that you said, I mean, depending on somebody's financial situation, they may have to rely on Mass Health or a MedX program or something like that, and it.
So yeah, long-term care, I could talk about that for a while. I probably won't, so we don't lose too many people, but basically a big feature, probably 50% of my practice, is what we call Medicaid planning, and that in practice is the preservation of assets against long-term care expenses. Now, most folks that I meet with nowadays, it was a little different 10 years ago when I started doing this, but most people don't have long-term care insurance. I don't know if everyone who's watching knows how much nursing homes cost, but approximately, depending on where you are in Massachusetts, and I'm going to be using a lot of Cape Cod-based numbers because that's where my practice is, but nursing homes on the Cape are between $400 to $550 a day.
Right.
So that's between $12,000 to $15,000 a month. Most of my clients are middle class, and most people don't have the finances to pay for that. And it's scary because you want to provide the best care that you can for your spouse, maybe, but you also don't want to lose everything that you've worked for so your entire life, and you're in the middle class. So what do? Well, spouses have options, okay, for sure.
Right.
The first thing I recommend that people do for Medicaid planning purposes for the future is that they sign special wills. And what these wills do is that, so Dick, I'm going to ask you personal questions. You've been married how long?
34 years.
So that is what we would call a long-term marriage. So I would look at your estate with you and your wife as being something that you've both contributed to equally, and you want to make sure that whoever passes away of the two of you first, that the survivor's going to have finances to live off of and also know that your home is going to be there for you.
And it doesn't get eaten up by a nursing home who takes what you've got in your estate.
So unfortunately, yeah, nursing homes it's a for-profit industry, so it's so expensive because the level of care is so high. Fortunately, the Commonwealth understands that, and we do have a lot of generous Medicaid programs that help supplement our seniors. The first thing that spouses should do is that you should each sign a special will for each other. Normally, when I meet folks, if they're just retired, they've had wills. If they've had them, they're what I call I love you wills, which means you leave everything directly to your spouse, no questions asked. But what we propose for retired folks is that you would consider these special wills that rather than leave everything directly to your spouse, you leave everything to a trust inside the will for the benefit of your spouse. And the most important language in that little trust inside the will is that it says that none of your assets can ever be used for nursing home care. It's a supplemental needs trust for your spouse. And what it does is that everything, if you passed away first, sorry to pick on you, Dick, if you passed away first, everything that...
I'm getting older.
Everything that you have titled in your individual name would go through your last will and testament and be protected for the benefit of your spouse for the rest of her life. And she would know that she would be able to live in her home and with resources to support herself, and not the government, but just in case, that she would be able to support herself because you left her that trust fund.
Now, what is the process that you talked with us a while ago? A tertiary? Is that what it was called? A trust? Something. I might have the word wrong.
Oh, well, we've talked about already the supplemental needs trust. Right. Oh, testamentary trust.
Testamentary.
That's what that will with a trust inside it has a fancy legal name. It's called a testamentary trust.
And you use fancy legal...
I try to be user-friendly.
Well, you call it legalese.
It is legalese. I speak a different language.
That's okay.
But so a lot of my clients, however, aren't married, and they often ask me, well, that's great that married people can sign those wills, but what can I do to save my house? The good news is that there is something that you can do to save your house, but Massachusetts follows the law that says that any transfers made not between a spouse, so is subject to a 5-year look-back period or a 5-year penalty period. And what that means is that if you gave me your house, you would not be eligible for long-term care from the Commonwealth, so Mass Health, for 5 years from the day of the conveyance. But
if you're at 80 years old or 85 years old, that's a difficult thing to
well, then it's
deal
a
with.
calculated risk. So I would do planning like that for anybody who wants it, but we're reviewing what your finances are, we're reviewing what your family situation is. And honestly, have been people who it's been a good decision for them to initiate a 5-year penalty period in their 80s. It's not super common because statistically and actuarially, we don't know what a life expectancy, if it's even going to be 5 years. What if we have a medical emergency?
Right.
We'd have to undo our good work. But for a lot of families, that's a calculated risk they're willing to take. So the main way that we save real estate in Massachusetts from long-term care expenses is very straightforward. If you're a single person or a couple, and let's say you have 3 children in this scenario, what you would do is you and your spouse or you individually would transfer your property to the people that you wanted to inherit it, the 3 kids. You, as the person who's giving the property, reserve in the deed something that's called a life estate, which is the lifetime right to use it and occupy the premises as your primary residence. It's yours. No one's ever going to throw you out of your home. After 5 years, the conveyance to the children with your life estate on that deed is not an asset that can be countable if you ever go into a nursing home and run out of liquid assets and need assistance from the Commonwealth and Mass Health to pay for it. The added benefit of this conveyance is that under current IRS interpretation and regulations, it's not a completed gift. But that's a good thing in this regard, because what it means is that when the kids inherit the property on the day you die, because you had a life estate, they get a step up in basis to date of death value. And that means that, so this happens a lot on Cape Cod. Say I bought my house for $10,000 in 1960, and I want to sell it now here or next year in 2020 for $500,000. The difference between $500,000 and $10,000 is $490,000.
Right.
So if that's not my primary residence and I'm a child who just inherited a property, I would have to pay capital gains taxes on my inheritance if my parent had just given me the property. But the life estate that they're reserving in the deed prevents that from becoming a completed gift and allows the property to be considered as an inherited property under IRS regulations. So you get a step up in basis to date of death value. So kids really like this too. Now the last wrinkle we like to throw into our life estate deeds, that's what they're called, life estate deeds, is something that's called a power of appointment. So this is very legalese, so I'm going to explain it in very layperson's terms. What this means
You're not going to say legalese again, right?
I won't. I'm sorry. It's very lawyerly.
Well, I mean, and you went to law school for how many years to learn to say legalese?
Only 3.
I'm just teasing you.
What I was talking about, the last feature of our life estate deed is that if I'm transferring the property to 3 children and I reserved a life estate for myself and everything's moving along fine, we're like 3 years into our penalty period, one of my children calls me and says, "Mom, I'm sorry. I got into a car accident and it was my fault." I always tell my clients, make sure your child is okay, but hang up on them and call me right away. Because what can happen when we put other people on our assets is that their creditors can become your creditors. The good news is that if my office has made your life estate deed, your house won't get attached by that child with the car accident's creditor, because I draft something into my deed that's called a power of appointment. So that gives me, as the person who gave the property, the right to change who my beneficiaries are on the deed. So I can take that child off temporarily until their legal matter is resolved, know that my creditors, his creditors, won't come and take my house and impact everyone's finances. And then later, when it's resolved, I can put them back on the deed through the power of appointment. So it's a really nice way to, if you determine that I definitely want to be in my house for the rest of my life, and I know that I want my children to be the people who inherit it, it's a really nice way to make it an asset that can be protected. So
I remember something that you said to me several weeks ago when I was talking to you about finance and taxes and those kinds of things, and you said something like this, and I'm paraphrasing, but you said, if you wait until you're ready to pass, Mass is going to kill you in terms of, not literally, but in terms of the taxes you're going to pay on the money in your estate.
So that is a really good point to bring up. Massachusetts has one of the lowest estate tax thresholds in the United States. Our estate tax threshold is only $1 million. The federal estate tax exemption amount this year in 2019 is $11.4 million. So we have a huge difference between the estate tax concerns here in Massachusetts and then having a federal issue. So I only have 1 or 2 clients that are federally taxable out of my hundreds of clients. Most of my clients, though, who consider themselves middle class, maybe 2 retired people with 2 IRAs and a small brokerage account and a house in Massachusetts, and all of a sudden, you're taxable.
I say this only in a joking way, but if you've got $1 million, you're middle class.
You are,
I mean, that's sad.
especially in the Commonwealth. Real property is so valuable here that people who don't consider themselves to be millionaires, you're a middle-class person, you're also a taxable person. So we want to take steps to minimize estate taxes if we can. Because the threshold is so low, it is difficult to really do a good job because it's all about balancing your assets between spouses, making sure that neither of the spouses is significantly over $1 million if possible, or not significantly above $500,000 if possible if you're really close to $1 million, so that we know that neither of the 2 spouses would pass away with $1 million in their name.
Right.
Every person has $1 million exemption to leave to their surviving spouse. So people with proper planning, if you have up to $2 million in assets, we should be able to minimize estate taxes greatly for you. And that's something that can be done, again, through planning, through those special testamentary wills that we make. I'm able to draft the marital credit shelter language into them. Some folks who maybe don't think that they'll ever be financially spending through their assets enough to require long-term care from MassHealth, they might just go to straight trust planning and skip the Medicaid planning. It really depends on what your concerns are. I will say that most people are happy to do Medicaid planning because of how expensive nursing homes are. A person who has an estate between $1.5 and $2 million will pay under $100,000 usually in estate taxes, whereas 1 year in a nursing home is at least $144,000. So a lot of people will make trade-offs when we're doing Medicaid versus estate tax planning because it's usually a better choice to go ahead with the Medicaid planning and accept the estate taxes versus doing no Medicaid planning, ending up in a nursing home for 10 years and then having nothing left.
Right.
So
right.
I do recommend that everyone see an elder lawyer. So there's estate planning attorneys, there's also elder law attorneys who we do, and I consider myself an elder law attorney because I specialize in estate planning, but I also specialize in the Medicaid piece of this and knowing the planning and all the laws and rules that we have to build into our estate plans, and they're 2 different things. And they should be taken in together. So definitely try to find an elder lawyer that will be able to answer your specific questions and also is very familiar with all of these planning vehicles. So definitely, there's a lot of us out there. We belong to the National Academy of Elder Law Attorneys, and you can search on their website to find someone closer to you in your zip code.
I think one thing that I forgot, or I didn't say at the beginning of this, is that you impressed me because you've gone to one of the best women's colleges in the Commonwealth of Massachusetts called Wellesley College.
I'm so fortunate to have gone there.
And also then going to Suffolk University and getting your
It's a
law
wonderful
degree.
law school. I'm very fortunate to have gone there too. I've been very fortunate with my educational experiences. Absolutely.
I wonder, is it true? Now, what am I going to ask? Is it true that the hardest part of getting a law degree is passing the bar?
It's true.
Is it really?
100%.
But you're happy you did it.
Absolutely. The law is something that is intellectually interesting, and this area of law is particularly interesting because I feel like I help people every day. And everyone should have access to attorneys that can help them with their situation. I know I personally do all of my pro bono at the Council on Aging's on the Upper Cape and Martha's Vineyard because I strongly believe that even if you're sitting here watching us or talking to a friend who's seen a lawyer and you don't think you need that, every person has the chance or the ability, in my perspective, if they meet with me, to get the documents they need. Because there shouldn't be any gatekeepers to this. These issues affect all of us. We're all going to pass away someday. We all have, hopefully, people that we want to benefit with our assets, and we should have the right to preserve them for those people.
Let me be a little kid for a minute. My mother told me I was never going to die. She said,
I'm sorry.
well, I guess she was probably wrong in that particular
Our
case.
as a mother, that's what we do with our kids. It's a really hard conversation to have for
That's
the
right.
little one.
That's right.
I know.
Yeah. Well, I think if I could close with an Irish blessing,
Oh, that's lovely.
and it's may the road rise up to meet you, may the wind be always at your back, the sunshine warm upon your face, the rain fall soft upon your fields. Until we meet again, may God hold you in the palm of His hand.
Oh, that's lovely. Thank you, Dick.
Thank you, Amy, very much.
That's my pleasure. Let's shake on it.